You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 73. What are reissue patents and do I need to file one? My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com. Or if that's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com, or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state. So feel free to contact me regardless of where you live. I'm now listed as the #1 patent law podcast on player.fm. I don't know how they rank them, but if it's anything to do based on listener audience, then thank you all for listening. And if you've enjoyed this podcast, a rating on iTunes is especially useful. Also, you can just drop me an email at adam@diamondpatentlaw.com and say what you've enjoyed about the podcast, or if you want me to do any particular episodes that I haven't done, drop me a line. I'm always very appreciative. What's also useful are any other kinds of reviews, such as Yelp reviews. So if you've listened to my podcast and it's helped you in some way, Yelp reviews for Diamond Patent Law at my Encino location would be the best way to do that. You might find a Century City location on Yelp as well, but that's not really active, and I really only work out of the Encino office. And that's all in the Los Angeles area. In this episode, I'm going to talk about a particular kind of patent application called a reissue patent application. In my other podcast episodes, I've talked about fairly common applications that are utility patents, which are continuation applications, continuation in part applications, and divisional patent applications. Go back to my previous episodes if you want to refresh your memory on those. There is another kind of application that isn't used as much, but you should know about it and when you should use it, and it's called a reissue application. And all the other kinds of continuing applications, you have to file them when one of your previous applications is still pending. Once your patent issues, you cannot file one of these continuing applications and claim priority to an issued patent if no other patent application in the family is still pending. This is what is different about a reissue application. In a reissue application, you already have a patent, but then you realize that there's some mistake in it and you want to correct it. You want the patent office to reissue your patent with the corrections. Now, not all things that need to be corrected, you can correct with a reissue application. Sometimes the simpler approach is called a request for certificate of correction. Now, I'll probably talk about those in the next episode. If you're talking about something simple like a typographical error or something really minor, then you could have a certificate of correction. And that's basically if the patent office doesn't need to re-examine your whole application because of some mistake. But if it's a bigger error, then you can't do a certificate of correction and you have to file a reissue application or some other ways to do it. So why might you want to file a reissue application? The Patent Office in the Manual for Patent Examining Procedure lists 4 main reasons. 1, the claims are too narrow or too broad. 2, the disclosure contains inaccuracies. 3, the applicant failed to or incorrectly claimed foreign priority. And 4, the applicant failed to make reference or incorrectly made reference to prior co-pending applications. Now, I could do episodes on each of these, but I'd say the main reason is the first one. The claims are too narrow or too broad. Now, there is a rule about when you're allowed to file a reissue. It's found in MPEP 1402. It says that the errors have to be based on an error that is, quote, deemed wholly or partly inoperative or invalid, by reason of a defective specification or drawing, or by reason of the patentee claiming more or less than he had a right to claim in the patent. I'm going to focus on the last part. The patentee claimed more or less than he had a right to claim in the patent. The best way to look at this is through an example, and I'm just going to make this one up. Let's say that you came up with a new kind of luggage. Now, in that luggage, you had all kinds of new fancy things. You have temperature control sensors. You have pressure sensors. You have a anti-theft tampering alarm. You had an air conditioning system to keep everything controlled. And let's say you got a patent on it because you figured out a really good way to put all these things into a piece of luggage. But let's say in the claims, you had the following, and this is really a gross oversimplification. It's not how you'd actually word this, but I'm just trying to get the point across about making your claims too narrow. You said, I claim a piece of luggage comprising an internal pressure sensor, a temperature sensor, an air conditioning system, a anti-theft system, and a handle on the top for carrying the luggage. Now, let's say you got this allowed because all the technical innovation that you did was for all these electrical components. Then you get your patent issued. All of a sudden, you realize that in order for someone to infringe your patent, they have to have a handle on the top because that's what you put in your claim. If someone puts a handle on the side or doesn't have a handle at all, they're not infringing your patent. And people will essentially be able to design around your patent because you made the mistake of claiming that the handle was part of your invention, when really the handle on top had nothing to do with the reason why you got the patent. This is the type of thing that a reissue patent application is good for, and this particular kind is called a broadening reissue patent application. If you're trying to broaden your claims, you don't have an unlimited time to do this. You only have 2 years from when your patent issued. If it's past 2 years, you're too late. So how do you do this? You submit a new application, you declare that there was an error in your issued patent, and you identify that error. And in your application, you could put in new drawings that clarify embodiments discussed in the original application, amend the text, add new claims to new embodiments. You can't add any new matter, which means that you can't put anything in that wasn't discussed in your original application, but you can clarify things, and you can write claims that are based on what was already discussed. Something else you can't do is try to broaden your claims for things that you did to narrow your claims during prosecution. And what I mean by this is that let's say in your original application, you had your independent claim for the luggage, the pressure and temperature sensors, the air conditioner, the anti-theft system without the handle. Then during prosecution, you added the handle limitation to try to get this allowed. You can't then go back and say, oh, I made a mistake. I really think that this wasn't necessary for me to add that. I want to take it out now. You can't do that because that's not really considered an error of a type that can be corrected in a reissue. Now, if your application was still pending, you could file one of the other types of applications and remove parts of those claims, like in a continuation application. But it's not something that's allowed in a reissue application. So after you file your reissue application, it's going to be examined like any other application. The patent examiner is going to review the prior art, say whether this application, whether it should be allowed. If you want to file a reissue application, it doesn't mean that you're actually giving up your original patent that's already issued. If your broadening reissue patent gets rejected, you still have your initial patent. If your reissue patent gets granted, then your original patent essentially is null and void because you have a broader patent now. So that's why you might want to file a broadening reissue application. Once your initial patent issues, you want to calendar 2 years from that date because that's the deadline. And when you see 2 years are coming up, then really take a closer look at your patent again. Look at how people are trying to knock off your product, and then file a broadening reissue patent application if you can. Now, if there are people that have been knocking off your product because they were clever enough to design around your claims, then what they have are called intervening rights. It's not fair to them that they weren't infringing your claims, spent time and money developing a product that didn't infringe your patent, and then you come along and broaden your patent so now they're infringing it. They're not going to owe you damages for what they've done while your patent was more narrow and for the time being, but for going forward, those infringers might owe you damages, and new people coming to the market that infringe your broader claims could be liable for damages. So that's the gist of it for broadening reissue patents, and probably the most common reason that you'd file a reissue patent application. You could also file a narrowing reissue patent application. Now, why would you want to do this? You have a broad patent, which is really good. Why would you want to go back to the patent office and say, I made a mistake, I shouldn't have gotten a patent this broad, please narrow my rights? Now, first of all, there's no duty for you to contact the patent office if you think that your patent is too broad. Once your patent issues, you don't have any more obligation to inform the patent office that you found some new prior art reference that might invalidate your patent. You can keep that to yourself, but you might not want to, and this is when a narrowing reissue patent application comes into play. There's no deadline to do this either. You could always file a reissue application to narrow your claims. So what might be one reason you want to do this? Let's say that you see someone is infringing your patent. You want to sue them. But then you also see your broad independent claim is just too broad. But they're still infringing your patent even if you narrowed your claims. In the example I gave, let's say that you have a claim for luggage that has a pressure sensor, temperature sensor, air conditioner, anti-theft, and you would also mention in your description that the fabric could be made from some type of bulletproof fabric. And you went into detail about this bulletproof fabric, but you didn't include it in your claims because you didn't think it was really that necessary for your invention to be patentable. Or maybe you included it as a dependent claim. Now let's say someone is making luggage that has all these things, including the bulletproof fabric. they'd be infringing your patent whether or not they used a bulletproof fabric because they had the pressure sensor, temperature sensor, anti-theft system, and air conditioner. But let's say that after you got your patent, you found out that something already existed that had all these elements, and you missed it. The examiner missed it. But if you had put in the claim about bulletproof fabric, then your patent would have gotten issued anyways, because that part of the invention is novel and non-obvious. What might happen is that you sue this person making a knockoff, having bulletproof fabric, and in addition to everything else. They are infringing your patent whether or not they're using the bulletproof fabric, so you sue them. And what they do is they turn around and file a case to have your patent invalidated because the luggage that's already in existence had pressure, temperature sensors, anti-theft, air conditioner, that was already in existence. So even though they're infringing your patent because they made something that has all the elements in your claims, your patent is invalidated because it never should have gotten issued in the first place. Now, this is what you want to avoid. You want to avoid people trying to invalidate your patents. So you file a narrowing reissue patent application. You do the same thing where you file a declaration that you made an error. You say that your claim was too broad, it should be narrowed to require bulletproof fabric. Now, let's say you're not really sure if your original patent would be invalidated. One thing you can do is you can keep your broad independent claim the same, but in the reissue application, you add in a new narrow dependent claim with the bulletproof fabric if you didn't have it already. That way, just in case your broad claim is found invalid, you still have a backup in your dependent claim that covers that particular embodiment of your invention. If you listen back to my episodes on types of claims, this is the exact reason why you have dependent claims. It's just in case your broad claims get invalidated, you have backup claims that are narrower that still might be considered valid. But if you never put that dependent claim in, then you're in trouble if your broad claim gets invalidated. But you can put in new dependent claims in a reissue application as long as they were discussed somewhere else in your original application. And you can do this because not including a narrower dependent claim is considered an error because omission of a narrower claim can render a patent partly inoperative by failing to protect the discussed invention to the full extent allowed by the law. That's just a quote from one of the cases. This was a fairly recent case called In Re Tanaka. So what happens after you file a narrowing reissue application? The application will be examined and you might get a reissue patent issued. Doing this makes it less likely that your competitors will be successful in invalidating your patent because you got it narrowed. Now, it does mean that there might be fewer infringers because you narrowed what your protection is for, but that's better than having your entire patent invalidated. There are other approaches to fixing things in a patent under what's called post-grant procedures, which I'll talk about in later episodes, and each has their own benefits and drawbacks, but a reissue application is one way to do it, and it's something you should consider doing if you plan on suing someone for patent infringement, and you see that your original patent could get invalidated because it's too broad. As I mentioned, there are other reasons for doing a reissue application, such as mistakes in claiming priority, so be aware of those mistakes as well, but I'd say the main thing to watch out for is whether your claims are sufficiently broad or sufficiently narrow. There are all kinds of rules and cases about what you can and can't do in reissue applications, and it can get a little bit complicated, but I'm just going over the basics, and you should review these things with your patent attorney. And also review Manual for Patent Examining Procedure. It's an MPEP 1402. And it's also not something I'd recommend doing on your own, but at least you know the basics of reissue applications. If you want help with your patent application, trademarks, responding to rejections, appeals, or anything else related to your invention, you can contact me through my website at diamentpatentlaw.com. That's DIAMENT, patentlaw.com. Or call me at 424-281-0162, email at adam@diamondpatentlaw.com. And I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.